I was sitting in my living room in Phoenix, Arizona, watching my 10-year-old daughter Emma practice her wheelchair skills when someone knocked on my door like they were trying to break it down. I wheeled myself over and opened it to find a woman in her mid-40s with blonde highlights, oversized sunglasses perched on her head, and a clipboard clutched against her chest like it was a religious artifact. "Hello, I'm Patricia Miller, president of the Saguaro Springs Homeowners Association," she announced, not waiting for me to respond before she started reading from her clipboard. "I'm here to inform you that you're in violation of several HOA regulations, and you have 72 hours to remedy the situation or face fines." I blinked at her, genuinely confused. My wife Deanna and I had only moved into this neighborhood 6 months ago, right after the accident that put both Emma and me in wheelchairs. We'd been careful to read through the HOA documents before purchasing the house. "What violations?" Patricia's lips pressed into a thin line as she gestured dramatically toward my driveway. "That ramp you installed is not in compliance with our architectural standards. The concrete is a different shade than the original driveway, and you didn't submit the proper paperwork for approval before construction. The ramp," I felt my blood pressure rising, "that's an accessibility modification. I need it to get in and out of my house." "That may be, Mr. Henderson, but rules are rules. Additionally, the handrails you installed by your front steps are black metal, and our community guidelines specifically state that all exterior fixtures must be brushed nickel or bronze. And don't even get me started on that parking space you painted in front of your garage." I looked past her at the accessibility parking space I'd painted in my own driveway on my own property with the universal wheelchair symbol clearly visible. "You're kidding me." "I assure you I am not. The HOA board takes our community standards very seriously. We have an image to maintain, and when homeowners start making unauthorized changes, it affects everyone's property values." She thrust a piece of paper at me. "This is your official notice of violation. You have until Monday at 5 p.m. to remove all non-compliant modifications, or you'll be fined $500 per day until compliance is achieved." It was Friday afternoon. She was giving me one weekend to undo the modifications that allowed me to actually use my house. "Look, Miss Miller, I understand you have rules, but these aren't cosmetic changes. These are medical necessities. My daughter and I are both paralyzed from the waist down. Without that ramp, we can't leave the house safely." Patricia's expression didn't soften even slightly. "Then you should have submitted the proper paperwork and waited for approval before making the modifications. We might have been able to work something out if you'd followed the correct procedure. Now we have to treat this as any other violation. The Fair Housing Act protects reasonable accessibility modifications," I said, trying to keep my voice level. "You can't force me to remove them." "The Fair Housing Act applies to landlords and renters, Mr. Henderson. This is a homeowners association. Different rules apply. I suggest you consult the CC and Articus you signed when you purchased your property." She turned on her heel and walked back to her white Mercedes SUV, leaving me holding the violation notice. I closed the door and looked down at the paper in my hands. Deanna came out of the kitchen, wiping her hands on a dish towel. "What was that about?" "The HOA wants us to remove the ramp, the handrails, and the parking space," I said, still trying to process what had just happened. "They're saying it's all unauthorized modifications." Diana's face went pale. "They can't do that, can they?" "I don't know, but I'm going to find out." I wheeled over to my desk and opened my laptop. The first thing I did was pull up the Fair Housing Amendments Act of 1988. I'd done my research before we bought the house, but I wanted to make sure I had my facts straight. The law was clear. Disabled individuals had the right to make reasonable modifications to their dwelling at their own expense, if necessary for their full enjoyment of the premises. The question was whether this applied to owner-occupied housing or just rentals. I kept reading and found what I was looking for. The Act covered both rental and owner-occupied housing, but there were some exemptions. HOAs weren't explicitly exempted, which meant they were covered under the law. I spent the rest of Friday evening researching, and found dozens of cases where HOAs had tried to prevent or remove accessibility modifications, and had been sued successfully under federal law. The Americans with Disabilities Act also came into play in some cases, though it was primarily the Fair Housing Act that provided the strongest protections for residential properties. By Saturday morning, I had a plan. I drafted a formal response to the HOA violation notice, citing the specific federal laws that protected my right to make accessibility modifications. I included case law precedents and legal citations. I kept the tone professional but firm. I was not removing the modifications, and they could not legally force me to do so. I printed the letter and drove over to Patricia Miller's house, which was listed as the HOA office address on their website. She answered the door in workout clothes, clearly not happy to see me on a Saturday morning. "Mr. Henderson, if you're here to argue about the violation, I suggest you save your breath and use the weekend to start making the necessary changes. I'm here to deliver my formal response to your notice." I handed her the envelope. "These modifications are protected under federal law, specifically the Fair Housing Amendments Act of 1988. I will not be removing them, and any fines you attempt to levy will be challenged in court." Patricia took the envelope but didn't open it. "We'll see what our attorney has to say about that. The HOA board meeting is Wednesday evening. I suggest you attend if you want to make your case, though I doubt it will change anything. We have rules for a reason." I drove home feeling frustrated but determined. Deanna was in the backyard with Emma, who was practicing her wheelchair basketball shots at the adjustable hoop we'd installed. Watching my daughter adapt to her new reality with such courage and determination made me even more resolved. She'd been in a car accident that had injured both of us. I'd been driving when a drunk driver ran a red light and T-boned us. Emma had been in the back seat. We'd both sustained spinal cord injuries. Mine was at L1, hers at L2. The doctors said we'd likely never walk again. The modifications we'd made weren't luxuries or conveniences. They were necessities that allowed us to live normal lives. The ramp had a gentle slope that met ADA specifications. The handrails provided stability and safety. The parking space ensured we had adequate room to get our wheelchairs in and out of the vehicle. None of these things hurt anyone or diminished property values. If anything, they made our home more accessible and potentially more valuable to a wider range of buyers. Sunday passed quietly. I worked on preparing for the Wednesday meeting, gathering more documentation and evidence. I also reached out to a disability rights attorney I'd found through an online search. Her name was Rebecca Torres, and she had extensive experience dealing with HOA discrimination cases. We had a phone consultation Sunday evening. I explained the situation, and she listened carefully before giving her assessment. "You're absolutely right about the law," Rebecca said. "The Fair Housing Act clearly protects your right to make these modifications. HOAs can request that you restore the property to its original condition when you sell, but they cannot force you to remove accessibility features while you're living there. The fact that they're threatening daily fines is particularly concerning because it constitutes harassment and discrimination based on disability." "So what should I do?" Attend their meeting, state your case calmly and clearly, and make sure everything is documented. Record the meeting if Arizona law allows it. Arizona is a one-party consent state, so you can legally record conversations you're part of. If they continue to threaten fines or legal action, we'll file a complaint with HUD and potentially pursue a lawsuit. How much would that cost? Let's not worry about that yet. Many of these cases are taken on contingency, and some result in the HOA being ordered to pay attorneys' fees. Right now, just focus on making your case at the meeting. Call me afterward and let me know how it goes. I felt better after talking to Rebecca. At least I knew I wasn't crazy and that the law really was on my side. The question was whether the HOA board would be reasonable once they understood the legal situation, or whether they'd dig in their heels and force a confrontation. Wednesday evening arrived too quickly. The HOA meeting was held at the community center, a nice building near the neighborhood entrance with a large meeting room. I arrived 15 minutes early and found about 20 other residents already there. Most of them were older, retired couples. A few younger families were scattered throughout the room. Everyone turned to look at me as I wheeled in, and I could feel the whispers starting. Patricia Miller sat at a long table at the front of the room with 4 other board members. There was an older man with white hair who looked like he'd rather be anywhere else, 2 middle-aged women who seemed to be Patricia's cronies, and a younger guy in his 30s who kept checking his phone. The meeting started with routine business. They discussed lawn maintenance standards, upcoming community events, and the budget for pool repairs. I waited patiently, my phone recording in my shirt pocket. Finally, Patricia announced that they'd be discussing a violation issue concerning my property. We have a situation with a homeowner who has made several unauthorized modifications to his property. Patricia began, not even using my name. These modifications are not in compliance with our architectural guidelines, and despite being given notice, the homeowner has refused to remedy the situation. I'd like to address the board, I said, raising my hand. Patricia looked annoyed but nodded. Mr. Henderson, you have 5 minutes. I wheeled to the front of the room and turned to face both the board and the assembled residents. Thank you. My name is Zachary Henderson, and I live at 4782 Desert Bloom Drive. 6 months ago, my family moved into this neighborhood. Shortly before we moved, my daughter and I were involved in a serious car accident that left both of us paralyzed from the waist down. The modifications I made to my property are not cosmetic choices. They're medical necessities that allow my 10-year-old daughter and me to safely enter and exit our home. I could see some of the residents nodding sympathetically. I continued. The ramp, handrails, and accessible parking space are all protected under the Fair Housing Amendments Act of 1988, which specifically protects the right of disabled individuals to make reasonable modifications to their homes. This is federal law, and it supersedes any HOA regulations. I'm not trying to be difficult or disrespectful of the community rules. I'm simply trying to live in my home safely. Patricia jumped in before I could continue. Mr. Henderson, while we're all sympathetic to your situation, the fact remains that you did not submit these modifications for approval. If you had gone through the proper channels, we might have been able to work something out. But you can't simply ignore our procedures and then claim special treatment after the fact. With respect, Miss Miller, I don't need your approval to make accessibility modifications. That's what the federal law says. I'm not asking for special treatment. I'm asking for equal treatment. The law recognizes that disabled individuals need the same access to housing that everyone else enjoys, and it provides protections to ensure that access. One of the other board members, the older man with white hair, spoke up. Patricia, maybe we should consult with our attorney before we proceed with fines. This does sound like it might be a legal issue beyond our authority. We've already consulted with our attorney, Donald, Patricia said sharply. He's reviewed the CC and Articus and confirmed that all modifications require board approval. Mr. Henderson violated that requirement. Did your attorney mention the Fair Housing Act? I asked. Patricia's jaw tightened. Our attorney is very familiar with all relevant laws. The board has made its decision. You have until Monday at 5 p.m. to remove the unauthorized modifications or fines will begin accruing at $500 per day. A woman from the audience stood up. This seems really harsh. The man is in a wheelchair. So is his daughter. How are they supposed to get in and out of their house without a ramp? We're not saying he can't have accommodations, Patricia replied. We're saying he needs to go through the proper approval process and ensure the modifications meet our aesthetic standards. There are ways to build ramps that blend better with the home's architecture. The ramp does blend with the architecture, I said. It's concrete, matching my driveway with a slope that meets ADA specifications. The only difference is a slight color variation because the concrete is newer. Another resident, a man in his 60s, stood up. I'm a retired contractor, and I drove by Henderson's place before the meeting to see what all the fuss was about. The modifications are tasteful and professional. You'd barely notice them if you weren't looking for them. This seems like a waste of everyone's time and money. Patricia was clearly losing control of the room. The board will take your comments under advisement, but our decision stands. Meeting adjourned. People started filing out, and several came up to me to express their support. One woman told me her sister had MS and dealt with similar issues with her HOA in California. The retired contractor, whose name was George, gave me his card and offered to testify or provide expert opinion if needed. I thanked everyone and headed home, where Diana was waiting anxiously. How did it go? About as well as expected. Patricia is digging in. They're going to start levying fines on Monday. I pulled out my phone and called Rebecca Torres, filling her in on the meeting. Okay, Rebecca said. Here's what we're going to do. Tomorrow morning, I'm filing a complaint with HUD on your behalf, alleging disability discrimination and Fair Housing Act violations. I'm also going to draft a cease and desist letter to the HOA, putting them on notice that any fines or further harassment will result in immediate legal action. In the meantime, don't remove anything from your property. We want to make it clear that they're trying to force you to remove legitimate accessibility features. Thursday morning, I received an email from Rebecca with copies of the HUD complaint and the cease and desist letter. The complaint was thorough, outlining all the modifications, the HOA's threats, and the specific ways they were violating federal law. The cease and desist letter was firm and professional, warning the HOA that they were exposing themselves to significant legal liability. Rebecca had the letter delivered to Patricia Miller via certified mail and also sent copies to each board member individually. The response came faster than I expected. Friday morning, I received a phone call from a man who identified himself as Richard Caldwell, the HOA's attorney. Mr. Henderson, I'm calling regarding the dispute between yourself and the Saguaro Springs HOA. I've reviewed your attorney's letter and the situation, and I'd like to see if we can resolve this without further escalation. I'm listening, I said cautiously. After consulting with the board, I've advised them that pursuing enforcement action against accessibility modifications would be legally problematic. The Fair Housing Act does provide protections for the types of modifications you've made. However, the board is concerned about setting a precedent for homeowners making changes without prior approval. So, what are you proposing? The board is willing to retroactively approve your modifications and waive the violations, provided you submit a formal modification request for their records and agree to restore the property to its original condition when you sell, if requested. The law already allows them to request restoration when I sell, so that's not a concession. And I'll submit the paperwork, but I want it in writing that the board acknowledges these modifications are protected under federal law and that no fines or penalties will be assessed. I can work with that. I'll draft an agreement and have it to your attorney by end of business today. I called Rebecca immediately after hanging up with Caldwell. Sounds like we won, she said, but let me review the agreement before you sign anything. I want to make sure there's no sneaky language that could cause problems later. The agreement arrived that afternoon, and Rebecca called me after reviewing it. It's actually pretty straightforward. They're acknowledging the Fair Housing Act protections, waiving all violations and fines, and agreeing not to take any action against your accessibility modifications. The only thing they're asking for is the formal paperwork and the standard restoration clause. I'd say we can accept this. So it's over, this part is, but I'd recommend we still file the HUD complaint. Even though they're backing down now, the fact that they tried this in the first place is a problem. HUD might want to investigate and ensure they're not discriminating against other residents. It's up to you, though. I thought about it. Part of me wanted to just accept the win and move on with my life. But another part of me recognized that Patricia Miller had only backed down because I'd had the resources and knowledge to fight back. What about other disabled residents who might not know their rights? What about the next person who moved into this neighborhood and needed accommodations? Let's file the complaint, I said. If nothing else, it puts them on notice and creates a record. Good choice. I'll submit it today. That evening, I signed the agreement and sent it back to Caldwell. The crisis was over. I could keep my ramp, my handrails, and my parking space. Emma could continue to safely enter and leave our home. Life could go back to normal, except it didn't, not really. Over the next few weeks, I started noticing tension in the neighborhood. Some residents went out of their way to be friendly and supportive, like George, the retired contractor, and a young couple named Mike and Sarah, who had a daughter Emma's age. But others seemed to side with Patricia, giving me cold looks when I wheeled past or avoiding eye contact altogether. The real problem started about 3 weeks after the agreement was signed. I came home from physical therapy one afternoon to find my accessible parking space painted over with regular concrete gray paint. The wheelchair symbol was completely covered. Someone had clearly done this deliberately and recently because the paint was still tacky. I took photos immediately and called Rebecca. "This is harassment," she said, "and possibly vandalism. Did you see anyone near your property?" "No, I was gone for 2 hours. It could have been anyone." "File a police report and send me the photos. This is going in our file for the HUD investigation." The Phoenix police sent an officer who took my statement and photos. He was sympathetic but realistic. Unless you have video of who did it or witnesses, there's not much we can do. It could be anyone, maybe not even someone from your neighborhood, but I'll file the report so you have a record. I decided to invest in security cameras. I had 4 installed over the weekend, covering my driveway, front door, backyard, and side yard. I also repainted the parking space, making the wheelchair symbol even larger and more visible than before. 2 days later, my cameras caught Patricia Miller walking up my driveway at 6 in the morning. She stood there for a full minute, staring at the repainted parking space, before pulling out her phone and taking photos. Then she walked back to her car and drove away. That afternoon, I received another violation notice in the mail. This one claimed that my parking space was excessively large and not in proportion with standard parking dimensions, and that the symbol was painted in a color that does not complement the home's exterior palette. I forwarded the photos and the new notice to Rebecca. "They're really not getting it, are they?" she said, sounding more amused than angry. "Okay, gloves are off. I'm filing a formal lawsuit in federal court. This is textbook harassment and retaliation. Will that be expensive? I'm taking this on contingency." This is exactly the kind of case I love to litigate. When we win, and we will win, the HOA will be ordered to pay attorneys' fees, damages, and possibly penalties. These people need to learn that federal civil rights laws aren't optional. The lawsuit was filed the following week. Rebecca Torres filed on my behalf in the United States District Court for the District of Arizona, alleging violations of the Fair Housing Act, harassment, discrimination based on disability, and retaliation. We were seeking injunctive relief, compensatory damages, punitive damages, and attorneys' fees. The neighborhood erupted when word got out. I started receiving letters from other homeowners, some supportive, others accusing me of being litigious and trying to bankrupt the HOA. A few people left anonymous notes on my door, ranging from encouragement to outright hostility. One note said, "Thank you for standing up to these bullies. My mother is disabled and dealt with similar problems. You're doing the right thing." Another said, "You're going to cost all of us thousands in legal fees and increased HOA dues. Hope your ramp is worth it." The most disturbing note was completely anonymous and simply said, "Accidents happen to people who cause trouble." I showed that one to the police, and they increased patrols in the neighborhood. I also made sure Deanna knew to be alert and to keep Emma close when she was outside. The thought that someone might try to intimidate or harm my family made me furious, but I wasn't backing down. The HOA's response to the lawsuit came a month later. Their attorney, Richard Caldwell, had apparently been replaced by a more aggressive firm from Scottsdale. The new attorney, Martin Vance, filed a motion to dismiss, arguing that the case was frivolous and that the HOA had already resolved the initial dispute. Rebecca filed an opposition that was absolutely devastating. She laid out the entire timeline, including the original violation notice, the threats of fines, the painted-over parking space, the second violation notice, and all the evidence of ongoing harassment. She included the threatening note as an exhibit, arguing that the HOA's actions had created a hostile environment that went beyond simple disagreement. The judge denied the motion to dismiss and scheduled a preliminary hearing for August. That was 4 months away, which gave us time to build our case, but also meant 4 more months of tension and uncertainty. During that time, I started connecting with other residents who had their own issues with the HOA. A woman named Carol had been fined repeatedly for having flower pots on her front porch that were allegedly the wrong color. An older couple, the Johnsons, had been threatened with legal action because their front lawn had brown patches during a drought when they were trying to conserve water. A young, single dad named Marcus had been cited for parking his work truck in his driveway overnight, even though it was a normal pickup truck, not some massive commercial vehicle. I realized that the HOA's behavior toward me wasn't an isolated incident. Patricia Miller and her board ran the HOA like petty tyrants, using rules and fines to control and punish residents who didn't fall in line. The disability discrimination I experienced was part of a larger pattern of abuse of power. Rebecca suggested that some of these other homeowners might want to file their own complaints or join a class action. George, the retired contractor, had been documenting HOA violations for years and had binders full of evidence showing selective enforcement and arbitrary rule changes. He was particularly upset because the HOA had forced his neighbor to remove a vegetable garden that allegedly violated landscaping standards, while Patricia Miller herself had an elaborate rose garden that technically violated the same rules. We started organizing. I created a private Facebook group for homeowners who had issues with the HOA. Within 2 weeks, we had 40 members. People shared their stories, their violation notices, and their frustrations. A pattern emerged. Patricia Miller and her inner circle were never cited for violations, no matter what they did. Everyone else was scrutinized constantly. One homeowner discovered that Patricia had actually had a fence built that exceeded the height limits specified in the CC and Articus. But when someone else tried to build a similar fence, they were denied approval. Another found evidence that one of the board members ran a home business that violated the HOA's strict prohibition on commercial activity in residential properties. The hypocrisy was stunning. These people who were so obsessed with enforcing rules on everyone else didn't think those same rules applied to them. Rebecca started incorporating some of this evidence into our case, arguing that the HOA's targeting of me was part of a pattern of selective enforcement and abuse of power. The judge seemed interested in this angle and ordered extensive discovery, requiring the HOA to produce all violation notices, board meeting minutes, and correspondence for the past 5 years. When those documents arrived, they were explosive. The discovery showed that Patricia Miller had personally initiated over 60% of all violation notices in the neighborhood, and that nearly all of them targeted people she'd had personal disputes with. There were emails where she referred to residents as troublemakers and discussed ways to make their lives difficult until they sell. Most damning was an email chain from right after my initial dispute where Patricia told the other board members, "We need to make an example of this wheelchair guy. If we let him get away with making changes without approval, everyone will think they can do whatever they want." Another board member had replied, "Are you sure we want to fight this? It seems like the modifications are legitimate." Patricia's response, "I don't care if they're legitimate. He didn't ask permission. That's what matters." Rebecca sent me the discovery documents, and I read them with growing anger and disgust. This wasn't about rules or property values or community standards. This was about a petty tyrant who couldn't stand being challenged. The preliminary hearing in August was brief but significant. Judge Margaret Chen listened to both sides' arguments and then addressed the HOA's attorney directly. "Mr. Vance, I've reviewed the discovery documents, and I have serious concerns about your client's conduct. The Fair Housing Act is very clear about disability rights and reasonable accommodations. The evidence suggests that your client not only violated federal law but did so knowingly and with malice. I'm ordering mediation, but I want you to understand that if this case goes to trial, your client is facing significant liability." Judge Chen scheduled mediation for September and strongly encouraged both sides to reach a settlement. As we left the courthouse, Rebecca was practically glowing. That was about as close to a victory as you can get at a preliminary hearing. The judge essentially told them they're going to lose. They'd be crazy not to settle. The mediation was held in a conference room at the courthouse with a professional mediator, a retired judge named Howard Klein. Patricia Miller was there with all the board members, their attorney Martin Vance, and a representative from their insurance company. The insurance company's presence was telling. It meant they were seriously considering settling because they didn't want to go to trial. Judge Klein had us start in separate rooms and went back and forth between them. Rebecca and I laid out our case, including the documentation of harassment, the discriminatory enforcement, and the emotional distress my family had suffered. We were asking for $50,000 in compensatory damages, $100,000 in punitive damages, a permanent injunction against the HOA taking any action regarding my accessibility modifications, mandatory Fair Housing Act training for the board, and attorney's fees. The first offer from the HOA's side came back after 2 hours. They'd agree to the injunction and training, pay my attorney's fees, and give me $10,000. No admission of wrongdoing. We countered at $125,000 total, with the injunction, training, attorney's fees, and a written apology to be posted on the HOA website and mailed to all residents. The mediation lasted 7 hours. We broke for lunch, came back, and kept negotiating. The insurance company clearly wanted this to go away. They'd done the math and realized that going to trial would cost them far more, both in legal fees and in potential damages if we won. The final settlement came together around 6 p.m. The HOA would pay $75,000 in damages, cover all my attorney's fees, agree to the permanent injunction, implement mandatory Fair Housing Act training for all board members, issue a written apology, and revise their CC and Articus to explicitly state that accessibility modifications were permitted under federal law and did not require prior board approval. Additionally, Patricia Miller would resign as board president, though she could remain on the board if she wanted. I looked at Rebecca. What do you think? It's a good settlement. You're getting most of what we asked for. They're admitting fault by agreeing to the policy changes and apology, and Patricia is being removed from power. Most importantly, you're protecting future residents who might need accommodations. That policy change is huge. I agreed to the settlement. We signed the papers right there, and it was done. The whole thing had taken 5 months from the initial violation notice to the final resolution, but it was finally over. The fallout in the neighborhood was immediate and divided. The homeowners who'd been supporting me were thrilled. Several of them had filed formal complaints with the board about Patricia Miller, using our case as ammunition. Within 2 weeks of the settlement, Patricia resigned from the board entirely, not just as president. George, the retired contractor, was elected as the new board president at an emergency meeting. One of his first acts was to review all outstanding violations and dismiss about half of them as petty or inconsistently enforced. He also implemented a new policy where violation notices had to be approved by a majority of the board, not issued unilaterally by one member. The written apology was posted on the HOA website and mailed to all 342 homes in Saguaro Springs. It was brief but clear, acknowledging that the board had violated federal law, had treated me unfairly, and was implementing new policies to ensure it never happened again. I used part of the settlement money to create a small accessibility fund for the neighborhood, offering to help any other disabled residents with modification costs. 2 families took me up on it. One was an elderly couple where the husband had Parkinson's disease and needed grab bars and ramp access. Another was a veteran with a prosthetic leg who needed some bathroom modifications. Emma started making real friends in the neighborhood once the tension died down. She and Sarah's daughter became inseparable, and they joined a local adaptive sports program together. Watching Emma play wheelchair basketball and swim in modified competitions gave me hope for her future in a way I hadn't felt since the accident. Deanna went back to work part-time as a graphic designer, working from home. The settlement money gave us financial breathing room and allowed us to make some additional modifications to the house, including a roll-in shower and a lift system for the pool we were planning to install in the backyard. About 6 months after the settlement, I ran into Patricia Miller at the grocery store. We made eye contact across the produce section, and for a moment I thought she might just turn and walk away. Instead, she came over to me. "Mr. Henderson," she said, her voice tight. "Miss Miller, I want you to know that I still think you handled this wrong. You should have come to the board first, worked with us instead of against us." I took a breath, reminding myself that nothing good would come from an argument in the middle of a grocery store. "Miss Miller, I tried to work with you. You threatened me with fines and refused to acknowledge that federal law protected my rights. Everything that happened after that was a result of the board's choices, not mine. You cost the HOA over $200,000 in legal fees and settlement costs. That's coming out of everyone's dues. No, Miss Miller, you cost the HOA that money by choosing to fight instead of following the law. I would have been happy to just live in my house in peace. You made that impossible." She stared at me for a long moment, and I could see she wanted to say something else, but she just shook her head and walked away. I later heard that she and her husband put their house on the market and moved to a different neighborhood in Scottsdale. The new HOA board under George's leadership was night and day different. They focused on actual community improvement projects rather than petty enforcement actions. They organized neighborhood events, improved the common areas, and generally tried to make Saguaro Springs a place where people wanted to live rather than a place where they felt constantly watched and criticized. I was asked to join the Architectural Review Committee, specifically to help ensure that accessibility concerns were properly considered in any rule changes or approval processes. I agreed, figuring I could help prevent what happened to me from happening to anyone else. One of my first recommendations was to create a clear, streamlined process for accessibility modifications. Instead of requiring full board review, we created a checklist of criteria. If the modification met safety standards, was professionally installed, and was reasonably necessary for disability access, it would be automatically approved with just a simple notification to the board. This took the subjective judgment out of the equation and made it clear that accessibility was a right, not a privilege that could be granted or denied based on someone's personal feelings. We also updated the CC and Articles to include explicit language about the Fair Housing Act and Americans with Disabilities Act, making it clear that federal law superseded any HOA rules when it came to disability rights. George insisted on having an attorney who specialized in fair housing law review all the changes to make sure we weren't creating any new legal problems. About a year after everything settled, I was sitting in my backyard by the pool we'd finally installed, watching Emma swim laps with her specialized flotation equipment. Deanna was reading on the patio, and the late afternoon Arizona sun was painting the sky in shades of orange and pink. My phone buzzed with a text from Rebecca Torres. Saw the news about Saguaro Springs HOA being featured in a Phoenix housing advocacy article as a model for disability accommodation. Congratulations on changing the culture there. You should be proud. I was proud, but more than that, I was relieved. The fight had been exhausting and stressful, and there had been times when I wondered if it was worth it. But sitting there watching my daughter swim, knowing that she could grow up in a neighborhood where her rights were respected and protected, I knew we'd made the right choice. The thing about standing up to bullies, whether they are individuals or institutions, is that it's never easy and it's never comfortable. It would have been simpler to just remove the ramp, paint over the parking space, and try to appease Patricia Miller and her board. But simple isn't always right. Sometimes you have to fight, not just for yourself, but for everyone who comes after you. I thought about other families who might move to Saguaro Springs in the future, families with disabled members who would need accommodations. Because of what we'd gone through, they wouldn't have to face the same battles. The rules were clear now. The protections were explicit. The culture had changed. That was worth every moment of stress, every threatening letter, every awkward encounter at the grocery store. We'd taken a community that was hostile to disability rights and turned it into one that embraced them. We'd replaced leadership that viewed rules as weapons with leadership that viewed rules as tools for creating a better community. Emma called out from the pool, "Dad, watch this." She did a flip turn that her physical therapist had been teaching her, executing it perfectly. I cheered and applauded, and she beamed with pride. Diana put down her book and came over to sit next to me. "You know what I realized today? This is the first time in a year that I've felt completely relaxed at home, like we actually belong here." "We do belong here," I said. "We earned it." The sun continued to set, casting long shadows across our backyard, across the pool where Emma continued to swim, across the ramp that led to our front door, across the accessible parking space in our driveway. These modifications weren't just practical necessities anymore. They were symbols of something bigger, something important. They represented the principle that everyone deserves equal access, equal opportunity, equal dignity. They represented the idea that our rights aren't up for negotiation, aren't subject to the whims of petty tyrants with clipboards and rule books. They represented the promise of federal laws like the Fair Housing Act, laws that recognize disability rights as civil rights, as human rights. Over the next few years, Saguaro Springs became known in the Phoenix area as a particularly accessible and welcoming neighborhood for people with disabilities. 2 more families with disabled members moved in, and both told me they'd specifically chosen the neighborhood because of our policy changes. One family had a son with cerebral palsy who used a wheelchair. Another had a mother with multiple sclerosis who lived with them and needed various accommodations. George and the new board continued to improve things. They added curb cuts throughout the neighborhood, installed accessible playground equipment at the community park, and even created an adaptive gardening area in the common spaces where raised beds allowed wheelchair users to participate in the community garden program. I sometimes gave talks at disability rights organizations and HOA management conferences, sharing our story and encouraging others to know their rights and stand up for them. Rebecca Torres and I co-authored an article for a housing law journal about HOA compliance with fair housing laws, using our case as a central example. The article got picked up by several national publications, and I started getting emails and calls from people across the country dealing with similar situations. I couldn't help everyone, but I tried to point people to resources, connect them with attorneys, and encourage them to fight when fighting was necessary. One email particularly stuck with me. It was from a woman in Florida whose HOA was trying to make her remove a ramp almost identical to mine. She'd read our story and decided to fight. She sent me a follow-up email 6 months later letting me know she'd won, the HOA had backed down, and they'd changed their policies. "Thank you for showing me it was possible," she wrote. "I was ready to give up and just sell the house." That's the thing about these fights. They're not just about the immediate situation. They're about setting precedents, changing cultures, and showing other people that standing up for your rights is possible and worthwhile. Every person who fights and wins makes it a little easier for the next person. Emma grew into a confident, capable young woman. She eventually competed at the national level in wheelchair basketball and won a scholarship to Arizona State University. When she was packing up to move into the accessible dorm, she turned to me and said, "Remember when the HOA wanted you to remove the ramp? I was so scared. I thought we were going to have to move." "I remember," I said, "but we didn't have to move. We stood our ground and we won." "You taught me something important," Emma said. "You taught me that having a disability doesn't mean accepting whatever accommodation other people are willing to give you. It means knowing your rights and demanding equal access." I've used that lesson 100 times. Whenever someone tries to tell me I can't do something, or can't go somewhere, or can't participate in something because of my wheelchair. That conversation was perhaps the most rewarding outcome of the whole ordeal. I'd fought not just to keep a ramp and a parking space, but to teach my daughter that she deserved equal treatment, that she didn't have to settle for less, that the law was on her side. Diana and I still live in Saguaro Springs. George served as HOA president for 3 terms before stepping down, and the next president continued his inclusive, common-sense approach to management. Patricia Miller's name became a cautionary tale in HOA circles, an example of what happens when power goes unchecked and when leaders prioritize control over community. The concrete ramp at my front door weathered and aged, blending even more with the original driveway. The black metal handrails developed a patina that gave them character. The accessible parking space faded, and I repainted it, this time with the help of neighbors who wanted to show their support. We made it a neighborhood event, with kids painting wheelchair symbols and accessibility messages in colorful chalk all over the driveway. Emma supervised, giving artistic direction from her chair. Sometimes when I pull into my driveway and see that parking space, I think about how close I came to giving in, to just accepting the HOA's demands and removing the modifications. I think about how different things would have been if I'd backed down. Emma would have grown up learning that people like us have to accept whatever we're given, that our needs are negotiable, that rules matter more than rights. Instead, she grew up learning that rights are worth fighting for, that the law protects people who need protection, that standing up to injustice is hard but necessary. Those are lessons worth more than any settlement check, more than any court victory. The legal framework that protected us, the Fair Housing Act and the Americans with Disabilities Act, exists because other people fought similar battles decades ago. They went to court, they challenged discrimination, they refused to accept second-class treatment. Every right we have was won by someone who decided that enough was enough, that things needed to change, that the law should protect the vulnerable instead of empowering those who would discriminate. I'm proud to be part of that tradition, proud to have added my small chapter to that ongoing story. The ramp stays, the handrails stay, the parking space stays, not because an HOA granted permission, but because federal law guarantees the right. That distinction matters. It's the difference between charity and justice, between accommodation and equality, between asking permission and demanding rights. As I write this, sitting on my back patio with the Arizona sun warming my face and Emma's laughter floating in from the pool where she's teaching adaptive swimming to younger kids in the neighborhood, I'm grateful for everything we went through. The stress, the uncertainty, the confrontations, all of it led to something better. Not just for us, but for everyone in Saguaro Springs, and maybe for some people beyond our neighborhood who heard the story and found courage in it. That's the power of standing up for what's right. It ripples outward in ways you can't always predict or measure. Somewhere, Someone facing a similar situation might read this and decide to fight. Somewhere, an HOA board member might think twice before targeting a disabled resident. Somewhere, a community might become a little more inclusive, a little more understanding, a little more just. The ramp at my front door is more than a way to get in and out of my house. It's a statement that I belong here, that my family belongs here, that our needs and rights matter just as much as anyone else's. It's a reminder that federal law means what it says, that the Fair Housing Act isn't just words on paper, but a living protection for real people facing real discrimination. It's a symbol of resistance against those who would abuse power and a beacon of hope for those who need to know their rights are protected. Every time I roll up that ramp, I remember why we fought and why it mattered. And every time, I'm grateful we didn't back down.